The U.S. Immigration Service just released a new policy which basically states that they can just outright deny your application at their discretion without first issuing an RFE or a NOID. Okay, so I read the news alert. I actually went in and read the full policy. And the reasoning behind this new policy, at least they say, is to deter frivolous filings, right? Like some people are in a rush, they want to get their application in, they know they're missing some items, but they're not too worried because the Immigration Service issues RFEs. So for example, if you're filing an application and you know that a passport is required, it's an initial form of evidence, and they use that word initial evidence. So if you know that there is like required initial evidence, then and you don't provide it, like this passport, they'll just deny it. Whereas before they used to issue an RFE or a NOID. So basically, the reasoning behind this policy is to deter this kind of frivolous filing, because in their opinion, people have been exploiting, this RFE procedure or NOID procedure. Like people know they're going to get a NOID or a RFE. And so they're not too worried. They'll just provide it whenever it's requested, but they got their application in. And mostly I think this applies for people who are out of status, falling out of status, and they want to get their application in so they can maintain status. So that's what they said, the reasoning behind this. Unfortunately, it does give a lot of discretion to a USCIS officer. They decide, what should have been included in this application. And so there's just, very much, an increasing chance of, errors on the part of the immigration officer, but I will say for EB-1A applications, I don't foresee this being an issue. But what I will say is that, the burden is on the applicant to submit a complete filing. So you do have to submit required documents. And when I say required, there is a list of initial evidence. And again, I'm putting that in quotes because it is called initial evidence. There is a list of the initial evidence that you have to include with every application. So make sure you include that. And very often they're like personal documents, right? Your passport, maybe your education degree, your birth certificate, things like that. So ensure that that is in your filing. So that would reduce the chances, right? That would reduce the chances of these kind of placeholder applications. So the other item I would mention, and that I'm more concerned about, is actually the policy says that the Immigration Service can issue an RFEs, but they do not have to give the maximum amount of time. So the maximum amount of time to respond to an RFE is 12 weeks. I mean, it's always been 12 weeks. So we know right off the bat that that will be the timeline. But what the Immigration Service is saying now is that they don't have to give the maximum. So an immigration officer can issue an RFE and decide whatever amount of time he or she wants to give you to respond to an RFE. So that's not good news. 12 weeks is already very, very quick to get an RFE response, out. So, that's a little concerning. But we'll have to see how all of this plays out. I do know people, do file applications as as placeholders. I think they are trying to stop that. So, and again, the immigration officers are going to look for initial evidence, to make sure you provide the initial evidence that's required for your application. I think you'll be okay. Again, what I'm more concerned about in the EB-1A context is the request for evidence timeline. So stay tuned. Obviously, as this gets implemented, we'll see more and more how it plays out. Very often these policies announcements are made, and then there's like pushback, and then it disappears.